going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Tuesday. Happy Tuesday. Let's see. What do I say next? You guys want to watch some court? I want to watch some court. I've got some spicy clips tonight, guys. And yeah, there's been, you know what? I'm just gonna, let's just get into the court case. I've got so much in my head right now. I don't know how to say it. So we're just gonna, let the videos talk for themselves. We are gonna start in Judge Goggins' courtroom. He is in Washington, and I've got two parts to this case. The first part happened about 3 weeks ago, and I saved it so I could play both of them together. And this guy did not disappoint today. It is a landlord-tenant case, but it's a spicy one because the tenant is big mad. He's big mad. So yeah, let's just get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
South Creek versus Jeffrey Tall. Jeffrey Tall was
Yes,
here.
sir.
Or there he is. Mr. Tall, it looks like this is first time up.
It is, Your Honor. It's a termination of tenancy matter. Corey Grand Mason
Okay.
appearing on behalf of South Creek.
Okay, good.
So, sir, I was going to ask you if we can adjourn it, and the reason why is I had Sherry Belknap as an attorney from Eastern Legal Services. I submitted all my evidence to her. South Creek rented to me with a cockroach infestation, and they still have it. So I submitted all kinds of pictures, videos of Sherry Belknap, evidence to where other places that have rented to me in the past that said I'm very respectful, always pay rent. All kinds of evidence. I've submitted. These people have ignored my ignored my situation for months, and I have where I sent them certified mail to where they refused it. All kinds.
If I said Washington, it's Michigan. I may have misspoke. I don't know if that's what you're saying, but if I did say it was in Washington, that is not the case. This is definitely Michigan.
Kinds of stuff. So all the evidence that I sent Sherry Belknap, she told me a couple days ago after I got my summons that she could not represent me because they did not have the resources. So I plan on going to jury trial and asking for damages and my money back. It's just been a total nightmare since I've been there. So now, before I even had 90 days in my lease, they were trying to cancel my lease that's supposed to be a year lease out of retaliation. So I can prove all this to you, but I need to have my situation adjourned so I can get my evidence to you so I can prove my case.
Your Honor, it's a first hearing. He has a right to seek legal counsel and to a jury trial based on all of the disclosures for these cases. If a counterclaim is filed or something prior to the next hearing, obviously this case will take a different path than the standard summary proceedings path. We just ask that a deadline be set to, I guess, put those items in motion if they're going to be done.
Okay, so
I need to
Mr.
know
Tall-
how I can get my evidence to you, sir. I got.
well, don't give me anything yet. We'll adjourn this matter to, I guess, just a week, March 4th. Then is that what we want to do?
Is there any way you can do too, so I can do all the legwork? Because from my understanding, I need to submit my evidence to the other party too. I don't know how to do all this. Like I said,
You're going to be in a spot if you don't hire an attorney. It's going to be kind of, I'm not saying you can't do it, but it's going to be more difficult. You need to probably speak with an attorney. But
well, I had Sherry Belknap, and
Yeah, I
according
know.
to her, as soon as
Yeah.
I sent her my summons the other day, she told me the exact text was, "They do not have the resources to help me."
Yeah.
This is what she said right here. Judge, how do I present my evidence? Judge Goggins does court by Zoom. If you have evidence that you want him to see, then you file it with the court and send a copy to the opposing attorney. Since it is your first hearing, you can request an adjournment to do so. Just let judge know that you have exhibits that you want to get to the court and to the other side. I do
Yeah.
not know how to do all this, and
Well,
I do
sir,
not
in the
understand.
Mr. Tell, you got to hold on. You got to bear with me though, because I'm the one that's hearing things, and I can't give you legal advice. That's going to be the biggest issue. The only thing I can do, I can give you an adjournment, and I guess right now, Mr. Graham Mason, I don't know. Do you want to do the week, or do you just want to do the 14-day period? And
Well, we'll
it's
do the week only. Well, let's see. When did
MB, this is extremely tame to what happened today. He gets even more heated today. Right now, he's I think this is his norm.
we file? Let me look and see when we filed
Sure.
this complaint. All right.
Looks like it was
We've
February 18th.
yeah, it looks like we signed it February the 12th. It
Yep.
probably was served sometime thereafter. So we're still looking at a week from now. I don't even think would fall under the 21 days to answer under the court rules. So
Yeah.
we're gonna have to go out to 2 weeks just to be on the safe side as far as preserving his right to respond.
Sure, and that's what I was thinking too, just to kind of cut through things a little bit. So we'll adjourn the matter to March 11th at 9:30. And Mr. Tall, the only advice I can give you is you gotta follow. I gotta follow the court rules for everybody. You can call Genesee County Bar Association too. Maybe they can help you out.
So
Okay.
no problem. I have no problem. So this is my question to you. Like I told you, I sent her probably 60 pictures of uploads
Yeah.
of cockroaches on my walls,
Okay.
just all kinds of just stuff, videos, letters from other renters I've rented from saying I'm very respectful, I always pay my rent.
Yeah.
All
Sure.
this stuff that I have, can I bring it to your courthouse and
Well,
give
you
it to you?
gotta, I gotta follow the court rules. I mean, you can certainly give it to me as one, just to put it in the file, but I'm not gonna look at it until we have our hearing. And also, Mr. Graham Mason has to have those same, whatever it is you give me, you gotta give him the same copy of all those things.
Mr. Who?
Okay? Graham Mason,
Me.
he's the one that's handling it.
Okay, how do I do all this? I'm not a lawyer. I don't know how to.
Sir, I know, and I can't, and unfortunately, I'm not trying to be mean or anything. I can't give you advice because once I give you advice and something's not what you thought it was, I'm going to be in a predicament.
Okay,
I
so
can't
how
do it.
about I get his address, email something. I don't know how to send the videos because I got to break them down smaller. I don't know how to do that.
Okay. Hold
but
on.
I have not violated any rules and I can prove it. It's all retaliation on their part. So all I want, if I bring all this to your court in an envelope and ask your secretary or whoever to hand it to you, I can do that, right? And I can also
I'll just put it in the file. I'm not going to look at anything, but I'll put that in the file. But you got to do what I'm telling you is Mr. Graham Mason's got to have all those things as well.
No problem. I'm writing it down. What's his name? How do you spell it?
First name is spelled Corey.
Corey. Oh,
Y.
Corey Mason.
Yep. Its last name is Grand Mason. GrandMaison.
Hold on. Maison.
Okay, and if you look at the court documents that have the address of care of Swistak Levine, the original court papers that you were served.
Yeah, you're
All right. They're going to spend about a minute passing documents or passing information back and forth. So I'm just going to keep this muted until we move to today. Because this is actually painful. Because, yeah, the guy doesn't stop talking long enough to hear his whole name. And he doesn't call him Grand Mason for the rest of the day or today's hearing. He keeps calling him Mr. Mason, which is kind of annoying. Anyways, Sashina, thank you so much for the 16 months. Sweet 16. Thank you so much, Sashina. That is awesome. Yep, I've got the follow up. So this part happened about 3 weeks ago. And then follow ups today. Today's a good one. I had this feeling that this was going to be a good hearing today, and I was not wrong. So I'm glad I held on to this clip, and I was waiting for it while everyone else was watching the soft sit jury trial that you couldn't hear, because anytime you watch a Judge O'Donnell stream, if you don't do anything to the volume, you can't hear it. So yeah, I was jumping around other courts. All right, let's see where they're at.
Me legal advice, but if Eastern Legal Services are telling me they do not have the resources to help me, you said I can do what now?
Call the Genesee County Bar Association is one of them. And also on the advice of rights that you got, also has a whole bunch of other, well, those are our financial assistants, I guess. Call the Genesee County Bar Association.
Okay, I will do that. And you said it's adjourned until March 11th at what time?
March 11th at 9:30.
Okay, thank you, sir.
You're welcome.
All right, have a good day.
You too.
Thank you.
Bye now.
Bye-bye.
Let's see. How about Mr. Mason? How about Pasadena?
Pasadena.
All right. Now we move on to today. And yeah, I don't really have anything else to say. Let's just go.
How about Mr. Graham Mason? We can go to South Creek versus Jeffrey Tall.
Okay. Corey Grand Mason appearing on behalf of South Creek.
And I know Mr. Tall's here. He's wanted to tell me some things. This is also an adjourned date. This is a termination of tenancy.
Yeah,
Go ahead,
Mr.
Graham.
Tull. Yeah, Mr. Tull had. I'm sorry. I'll let him make his appearance first. I apologize.
Yeah, Mr. Tall, you there?
Yeah, I can hear you.
Okay. Mr. Graham Mason?
Yes. Last time we were here, Mr. Tull had specified that he was either going to file some documents either with the court, forward them to me, file a response, file a counterclaim, something. And we haven't received anything since the last hearing regarding any of those things. And so we're seeking a termination of the tenancy based on our pleadings and based on the notice to quit that was forwarded as part of the 30-day notice.
Okay, and I don't know, Mr. Graham Mason, if you received what I got. I've got stated March, looks like March 6th, a letter. It's a handwritten note stating issues with cockroaches from Mr. Tull.
Yeah, you should have pictures too. I sent it to him.
You sent it to Mr. Graham
I
Mason?
sent it to him and you, certified mail. You should have the blown up pictures in color from Staples. They got bugs all over their house. They still got bugs. I
Okay.
tried to pay them rent. Jarrett Levine called Allison, office manager. She declined to accept anything from me. All I wanted was the bugs to be gone. That's it. She rented a place with me with cockroaches, said she'd get rid of them, still hasn't got rid of them. I actually sat there and she seen me yesterday with the U-Haul moving most of my stuff out because they still got bugs that are coming out of the walls. So I'm in the process of leaving on my own accord. I got a new address and everything. The only thing I got to do is get the stuff out of my fridge and a couple other things and I'm gone. But I am seeking damages for all my stuff. I got like $5,000 worth of stuff that I need replaced because they're going to be laying eggs in my stuff. I requested all the money that I've given these people since I've been there. They have not offered me my deposit back. They didn't even have the courtesy to build me cabinets the whole time I was there. These guys ignored me the entire time I've been there. Corporate has ignored me. They have ignored me. I've sent you a letter from Highland Estates where I was at 3 years. And the lady said, if you have any questions about me not paying rent or my behavior, she'd be willing to talk to you. I'm actually at Highland Estates right now on their tablet. Since they say I'm such a horrible person, I'm at Highland Estates on their tablet talking to you right now, sir. I sent Corey Mason and you pictures of cockroaches, a reference letter from Sherry Gordoa from Highland Estates. I had videos of them climbing all over my walls. I didn't know how to send it to you. Um, the only victim here is me. The only reason why she's wanted me out is over retaliation. So I took it upon myself, and she can even tell you, because her and the maintenance man drove by several times and seen a U-Haul at my house. I got another location. After today, I'll have all my stuff gone anyway. All I want is recovery for my damages. I got to replace all my stuff. Now my kid's mother has bugs because him dragging his clothes back and forth. Who pays for that? Who pays for my new place to have a pest control person out there? This is all courtesy from Allison from South Creek Village, because she told me she did not legally have to tell me that they had a cockroach infestation. This place has been done 12 times and they still have bugs.
Mr. Graham Mason?
Your Honor, if he's in the process of moving out, it makes our lawsuit moot. I would rather enter into a consent decree or a conditional dismissal at this time, saying that he'll be out by a date certain. And he's more than willing to file a countersuit at this point, but I don't have any legal documents before me that would, address any of Mr. Tull's issues.
I sent it to you. You got the same package as Mr. Goggins. I've blown up pictures of cockroaches and everything.
Sir, that's evidence for this matter. It's not it's not legal filings to request any type of relief from the court.
Me legally.
And again, I don't care, Your Honor. This has everything. I don't
care either. I shouldn't have to pay to live with bugs.
Mr. Tull, you can't speak over everybody. I appreciate you won't tell me a bunch of stuff.
Because
I know
the whole situation, they want all this money from me, but they would not accept my rent. They're saying that I'm intimidating staff, sitting there interfering with pest control. I never did none of that stuff. If I did, bring the evidence on. The actual situation reality is they don't care. I have an autistic kid. I just lost my job because my transmission in my car went out. They want all this money for back rent, but they didn't even get rid of the bugs. The whole reason why we're in this situation is because her dishonesty. So they should have to pay the court costs too. Why should I got to pay $1,000 a month to live with cockroaches?
Sir, this is just strictly.
Biggin, thank you so much for the raid, my friend. I appreciate it. Welcome to all the Biggin Raiders. You guys are coming in right in the middle of a landlord-tenant dispute where Mr. Tull up here has he's got a lot of claims against his landlord, and they're not good. They're not good claims. He doesn't seem like a guy that's gonna let this go lightly. Let's just say that. He's very angry and understandable, and yeah. So that's about where we're at. We're actually almost finished with this one. We only have a couple minutes left. But this guy has cockroaches all over his house. And, I think they said trailer. He's living in a trailer. So he's moving back to the place that he just moved out of. He's only been here for 3 months. All right. I think that's about it. So, Biggin, thanks again for the raid. I do appreciate it. Welcome to the Raiders.
A termination. It sounds like you're moving. Sounds like Mr. Graham Mason wants you to move. How much time do you need to move at this point? Or maybe you moved out.
This is what I request from you, Your Honor. I can't make you, but this is my request. Okay. All I want is this. I don't want an eviction on my tenancy record because I don't feel like I should have to get one. Okay. That's number one. I'm willing to leave on my own accord, because they still got bugs. They didn't tell me to leave. You didn't tell me to leave. I'm so sick and tired of seeing these things on my wall. So all I need is to the end of the day, they can have their trailer. I'll leave their keys right on the counter. All I want is for you to cancel the lease, because all they're going to try to do, they're breaking the lease. They wanted me out of there. They sent me a letter on the 10th saying to leave because I violated the community rules, or they're evicting me. I never wanted to leave. All I wanted was the bugs gone. So my request to you, sir, is that you cancel the lease so they can't come after me for back payment. I shouldn't have to pay anyway. 2, give me to the end of the day to get out. No problem. They can have their stuff. 3, make them pay the court costs because they're the whole reason why we're here. And 4, I think I should have damages granted my way. I mean, I've been through a lot of crap living there for the last 4 months. I have an autistic child. I'm basically a single parent. I have no car now. I have no job because my transmission died. These people are a multi-million-dollar company. I don't even have a job. So all I ask for you, Mr. Goggins, is that you cancel the year lease. Give me to the end of the day to move out. And I mean, I shouldn't have to have back pay. I'm the victim. They're the ones that sat there and rented a roach infested.
I think
All right. First and foremost, it is not Mr. Goggins. It is Judge Goggins. That upsets me a lot. That always bothers me when people do that. Also, you're getting most of what you're asking for, man. They're allowing you to leave without charging you, so your lease is going to be thrown out. It sounds like you're going to get a dismissal or a consent judgment to dismiss the case once you're gone. Just calm down, man. You are going to have to file a separate suit if you're going after damages, though. You can't do that here. You can't. Or if you would have filed a counterclaim to this, Judge Goggins would have heard it, but you didn't. So you gotta do it the right way, which you probably should do if what he says is true.
Okay, Mr. Tall, let me speak now. Okay,
No problem.
Hold on. So, because quite frankly, everything you're asking for, you're going to get for the most part. Now, I can't order damages, but what I can do is just do. Hold on. The only thing I can do in this case is just regarding the lease. Mr. Graham Mason, with regard to him moving, honestly, it makes more sense. I appreciate the offer of conditional dismissal. I don't know if we're going to get there or not. Okay, if Mr. Tall, can you agree to move by, I guess, within a couple days? Is that what you want to do?
No problem. I'll be out of here by the end of the day. All I want you to do, sir, if you're not going to grant me damages, all I want you to do is cancel my lease. Please do not put an eviction on my rental record. I have a kid to take care of. And please don't make me pay past rent. I mean, if you're not going to grant me damages for all the stuff I've been through, let it be an even-Steven thing. Cancel the lease and let me get on with my life.
Yeah. And as Mr. Graham Mason, mostly, I think it sounds like everything's doable. I mean,
yeah,
the conditional dismissal.
I'm just thinking about how to craft this in my mind so it's not punitive to Mr. Tull.
Yeah.
I figure we could enter into a consent judgment that includes a move-out date of this Friday. I don't believe that it would be if another court were to review this and say that he needed to be out by today or tomorrow. I don't think that would be acceptable.
Right.
And in addition to that, there could be a provision on line 10 saying that in the event that he moves out prior to the date, that that plaintiff would enter a dismissal of the case.
I think, and honestly, Mr. Tull, this is for your sake more than anything else. There's statutory time period. I kind of feel like I got to follow with the 10-day, Mr. Graham Mason.
Yeah, I mean, that would put us on a Friday, I believe, which is
that's what you were talking about. I'm sorry.
The 21st. Yep.
Yeah. So that gives you till. Well, hold on. Let me get through my thinking first. It'd be the 21st. Today's the 11th, so that would be the statutory time period to move. Other than just moving, that's all we've got. And then, what did you want to say, Mr. Tull?
I just want to. I want 60 more seconds of your time, and I'll set whatever ruling you hand down. Okay. I am moving out of my own accord because I'm.
How much you guys want to bet that he says the exact same thing he said 2 minutes ago? How much you guys want to bet?
Sick of bugs crawling up my wall.
Sure.
Okay. She sat there and told me you can ask her. She's on here. I hear her. I told her, I said, I would have never moved in if you guys told me you were infested with cockroaches. She said, I do not legally have to tell you that. So Jared Levine talked to her last month, and I told her when they gave me a 7-day notice for $860 to pay rent after the notice to vacate because I supposedly violated the rules. I told her I will pay, get rid of the bugs. They refused to accept payment from me. You know, all I wanted, you can't grant me damages, but this is my question to you. Who pays for all my belongings? Who pays for my kid's mother for her house to be sprayed with pesticides? Who pays for my new place? This is all courtesy of South Creek Village. So if you can't grant me that, I really don't understand why. But all
I
I
can't
want
do it today. I just can't do it today. I don't, you can file any action.
Yeah, that's exactly why I put Slumlord in the title. For that line right there. That's just, if this is true, I mean, there's no real way of knowing. It's just Mr. Toll's word that I wouldn't have moved in here if you would have told me there were cockroaches everywhere. We don't have to legally tell you that. That is such a shitty thing to respond with. I hope it's not true. I really do. But that line is why Slumlord is in the title.
You want, I'll consider whatever you want to file, but I can't do it just for today on this
Well, I
lease
am
agreement.
going to file because these people ruled my entire life over dishonesty. They didn't
Okay.
even build me. They didn't even have the courtesy to build me cupboards. I got all kinds of pictures. I got videos. I got everything. So all I ask you for today, sir, you want to give me the end of the week to move? That's fine. I'll be out here today. All I want is my lease canceled. I don't want to have to pay any back dues because I feel they owe me. And I want to move on with my life. They can have their bug infested trailer. All they're going to do is trick someone else and rent it to them and let me move on with my life. I plan on seeking damages. We'll do that at another day. But
Okay. All right.
all I want from you, Mr. Goggins, please cancel my lease. Please do not put this on my rental record. I have an autistic child to take care of. I don't deserve it. And 3, I just want to move on with my life. I'm sorry I ever moved in there. They can have their key. I'll leave it on the counter. I just don't want this on my record because I have a child to take care of. I need people to rent to me. Okay. I did not pay them because I didn't want to. They told Jared Levine they refused to accept any payment from me.
Okay. So let me work through with Mr. Graham Mason. How do you want to word it?
I still think that my last proposal accomplishes what Mr. Tull wants. It does 2 things. It gives him a period of time to move out that's acceptable to the legal standards that you're required to provide as part of your ruling. And then it also allows for him to have no record of this case because upon his moving out, the case itself will be dismissed. If that's acceptable to the court, I can easily prepare an order that provides for that. As far as the other items, the damages, those types of things, I can't speak to those because I don't have a counterclaim or a lawsuit in front of me regarding that.
Yeah, and I'm not going to get it today for both of you at any rate. So let's just do Mr. Tolkien.
Heather, 17 months. That's what we're up to. We had Sashina earlier with 16. Heather's at 17. Heather was the number 1 member, or the first member, which, yes, she's also the number 1 member. So we're up to 17 months. That is awesome. Thank you so much, Heather. Heather.
I guess I could just order it, I guess.
After a hearing, you can just order it.
Yeah,
and
let's just order
I think by doing it that way, it requires me to check and find out, and if he has moved out by the date determined based on the additional language in the order, I'm required to file a dismissal at that point, which then cures everything. And if you make the order, there's also no opportunity except for an appeal to come back before the court.
Yeah, and that works out for both of you, quite honestly.
I'm already 95% moved out. I had a U-Haul yesterday. All I got to do is go back. I'm having my handicapped father take me, because I have no car now, take me to South Creek. I'm going to clean my fridge out, clean the rest of my belongings out, leave their mailbox key and leave their key on the counter. They can do whatever they want. Like I said, all I want is the lease canceled. I do not want this on my rental record. I don't feel like I owe any back dues. I feel like they owe me. And as far as the lawsuit, I can file at another date. Sherry Belknap told me to tell you guys, give you my forwarding address in case you guys need to do what you got to do. So I would like to give you my forwarding address, please.
Okay, so I guess, Mr. Graham, can you just take the forwarding address so we can get that part over? Or you want to leave it?
Yes, that's fine. I understand under the
So
the rules regarding any type of security deposits and the like. The forwarding address is required. Yes.
Where's my security deposit too? They didn't even give me my security deposit. They didn't even.
You're not moved out. Your Honor, let's just get the address so we can wrap this up. I'm sorry, Your Honor.
Yeah, that's okay.
Well, reality, Your Honor, is I'm the only one going through all this. No one else cares. I'm the only one going through this.
Mr. Tell, let's just kind of.
No problem. No problem. Okay, here's the address.
Okay.
It's 1050.
All right, you gotta mute it for the address. You know, this at least isn't as difficult as it was the last hearing. All right, I think we're done.
Okay, and then we'll do it is in the order that Mr. Graham Mason just do it. The court orders that Mr. Tall will be moved out within 10 days. We'll do the March 21st. If moved out within that time period, case is dismissed.
I'll move out today.
Yeah, that's fine. You can do that, Mr. Tall. But this way, I have to follow some rules. I got to give you that 10-day time period by statute. So I got to give you 10 days. And that gives you a leeway. If you're moved out today, great. You know, that's fine.
Okay, so I got to move out by when for you to dismiss it? What time?
March 21st.
Okay, so this is not going to be on my rental record, right?
It's going to show up as dismissed. The case will show up dismissed as long as you moved out by then.
By the 21st. No problem. I will leave their keys on the counter. I know Allison's on the Zoom call. I see her. She can have the keys on the counter. I'll be out of here the day. So I have no back cost. And if I want to pursue this later on, how do I do that, sir?
Well, I can't give you legal advice. All I can tell you is that you can file a claim for damages resulting from any.
That's what I would like to do at a later date.
Yeah, you can do that at a later date. Yeah.
Okay, no problem. I will be out of there today. You guys got my forwarding address. Keys will be on the counter. I appreciate your fairness. And thank you very much. That's all I wanted.
Well, thank you, Mr. Tall. I appreciate your civility too. I really do. Mr. Graham Mason, does that cover everything? We got it?
I believe in that matter. It covers everything. Thank you, Your Honor.
Okay. All right, Mr. Tall, good luck to you too. And we'll likely see you later, huh?
All right. Okay. Thank you, sir. Bye.
All right. Bye now.
All right. Bye-bye.
Bye.
That one was fun, right? Yay! It's over. Yay! We will absolutely see that guy again. He's maybe not. He kind of got everything he wants besides damages. It's going to be really hard for him to claim much for damages. He's going to have to prove the amount that he lost. But if he goes after him for damages, I wonder if the landlord can then claim the missed rent. I wonder if it would cancel each other out. I don't know. All right, let's move on. Let's just move on. What do we have next? The next one, the attorney in trouble? Yep. This is what you don't do if you're an attorney. Just saying. I'm not one yet, but this is what you don't do.
Mr. Maple?
Yes, ma'am.
So a couple of questions, sir. Have you paid Mr. Dark?
Yeah.
You're not in negotiations. You've actually paid him to show up.
Yeah, I paid him.
Okay, because this is a problem. Because as soon as you paid him, he should have done an entry of appearance. You've been here at least 3 times, and he's never shown up. And I have a problem with that. And I can't really compel him until he's done an entry of appearance. Otherwise, to us, you have no attorney. And this is an old case, so this needs to move.
I agree. I agree. Let me try to get in contact with his office.
All right, you got a number for him?
Yes, ma'am.
Give me that number.
Okay. It is 77.
All right. Not we're not putting this. We're not blasting this attorney's number out there.
07. And would you like his office as well?
Yeah.
Okay.
Vic, thank you so much for the super chat, and thank you for the late fee. I appreciate it. And darn YouTube, get better at notifications.
Okay.
That's
All right,
his
thank you.
legal assistant as well.
Okay.
Yeah, when a judge calls you up from the bench, probably not your day. Just saying. I'm not going to spoil it. Not going to spoil it, peeps.
Judge, Mr. Edie is requesting another breakout room with Mr. Major.
Okay.
Judge Middleton does. I think that's awesome when he does that. No, he hired an attorney. He paid his attorney, and his attorney hasn't done anything. This is now the third time that Mr. Maple has been in court, and the attorney has yet to show up or file an appearance.
Record your message and press pound or
Leave a passive-aggressive message. Terry, thank you. Appreciate it. And I agree. It's like I just said that. Thank you, Terry. I appreciate it.
Start. Please leave a message with your name, your number. I'll be sure to reach you soon.
This is Judge Tammi Long Hayward, State Court of Clayton County. Your client, Mr. Maple, has been before me at least 3 times contending that you're his attorney and that he's paid you to appear, but there is no appearance on the records. I'm going to offer him the opportunity to have appointed counsel if he wishes so that we can move this case. And then he can settle with you regarding the fee.
Javal, I actually thought that too. But because this is the third hearing that they've been to, I'm going to guess that they've looked up and found out this guy's actually an attorney. It's just my guess. Otherwise, I feel like this would be a completely different conversation.
Judge, I just got a text message from his legal assistant saying that he took a leave of absence.
No.
Yeah, I don't.
What's the legal assistance number again?
That was 77.
Is that the number she texted you from?
Yeah, that's the number he texted me from, his legal assistant, Mr. Lewis.
Morning. Thank you for calling Dark and Dark. This is yours. Can I help you?
Sir, Mr. Dark is playing games with me and his client, and I'm a little tired of it. This is about the third time Mr. Maple's been here, and every time he's represented that Mr. Dark represents him. And I asked the appropriate questions, as in, has he been fully paid to appear? The answer that I've gotten is yes. If that is the case, then Mr. Dark is derelict in his duty to file an appearance and to appear in my courtroom. And now Mr. Maple is being told by text that there's a leave of absence. I'm not recognizing a leave of absence. This is video court. Wherever he is in the world, he can sign on.
Hey, this is Roland Nelson. I'm here. I'm sorry I'm late.
Hold on, Mr. Nelson. Excuse me.
I understand.
Tell him, no. Tell him he signs on in the next 10 minutes, or I'm reporting him to the bar for dereliction of duty. I'm sure it's in one of them bar rules. I'll find it.
Okay, so
No. Okay, so tell him to sign on to my Zoom call. Thank you. All right. Take care. All right. Next.
Your Honor, I do have a bit of an update for Mr. Maple.
Oh, I cut out a little bit. There was about I don't know, about 30 seconds that I cut out. I don't know why. It was an accident, but Mr. Maple talked to the public defender just to see what the public defender would tell him to do, because this is the third adjournment now for his attorney that hasn't showed up. So the public defender is speaking on his behalf just for the short meeting they just had. That's just a follow-up for what we missed.
All right, I'm good. Go ahead.
So, Judge, I did speak to Mr. Maple, and I think the conclusion we came to is that he wants this case to be continued 1 week for him to just try to get an understanding of what's going on with his attorney. But if he doesn't get a satisfactory answer to that, then he wants the court to appoint us next week, and we would enter a not guilty plea at next week and go from there, if that satisfies the court.
I'm fine with it. All right. We'll see you next week. Mr. Maple, Mr. Dark needs to show up. He's playing with me at this point. I'm not doing this. This case has been on the calendar for too long. If you hired him, he needs to do his job. If he can't do the job, then he needs to go.
I understand. I agree.
All right. Thank you. Because filing a leave of absence at the last minute, that's not even the rules don't even allow that. He knows better, or he should. All right.
Judge,
thank you.
Just to clarify, he's going to be continued to next Tuesday's jail
Yes.
calendar? Okay.
Yes.
Okay.
All right, that was it for that one. I'm going to follow that up next week, and I really hope Mr. Dark appears, the attorney. I really hope he appears, and I want to be a fly on the wall for that conversation. I absolutely do, and we get that opportunity because of YouTube. All right, so let's move on. That one was good. Let's see what else we got now. What else we got? I'm so sorry. The second I realized what this was, you guys are gonna love this. This you can't make this stuff up.
Is Angelica Leha, 24-02775, appearance, please.
Councilman Kaplan, for the city, Your Honor.
You can give it back to.
Jeffrey Kaplan, P74943, on behalf of the defendant. She's appearing by Zoom.
Okay, today was the date set for a sentencing. I do have a pre-sentence report. It was prepared on the 10th of March. Did you get a copy?
I have, Your Honor, and I have no corrections, edits, or deletions.
Your Honor, I am again covering for Lawrence Sutton. We have received the pre-sentence investigation report. We have no changes.
You can make allocution.
Nothing from the city, Your Honor.
Your Honor, I'm just going to keep it brief on reviewing the report. It indicates that she's moderate to low risk, recommending 8 months of probation. We just ask that you follow the recommendation, Your Honor.
The client wish to make a statement.
Ms. Leisure, you got to take yourself off mute. Do you wish to make a statement? You got to take yourself off mute, Ms. Leisure.
Sorry, I was forced to leave mute. What was the question again? I'm sorry.
Did you want to make a statement to the court at this time before I sentence you?
Yes. Actually, was trying to see if I could have it dismissed. I mean, because it's been over a year. I haven't had any trouble or gotten into any trouble. Actually, it was just one mistake I went through and a bad timing at that moment. I just been out of trouble. I mean, I work very hard. I got 4 children I take care of. So it was just a bad time at that moment. But I've been doing really good, been out of trouble and just working really hard and proving to be, I mean, doing right, actually.
Good. Well,
All right. That's not a terrible thing to ask for. I mean, all defendants want their cases dismissed. So, yeah, don't use your statement to the court where you're supposed to be apologizing for your actions. Don't take that as a time to ask for a dismissal. You have an attorney. If you would have said that to the attorney, he probably would have laughed at you. Wait till you hear what her charge was. And she wants it dismissed. This, again, you can't make this up.
you should be doing right. Your mom, this was 2024, was this incident a year ago?
Correct.
I don't know what you're asking to be dismissed. You nothing, you're not here for a dismissal of a matter. You pled to an amended charge of operating while intoxicated. That means it started off higher than a regular operating while intoxicated. It was charged as a super drunk.
Mm-hmm.
Get a 0.29 blood alcohol. Do you know what the legal alcohol limit is?
No, I don't, Your Honor. I'm sorry.
Anything above a 0.08 is above the legal limit. You know how many times you were above the legal limit?
I did read it on a paper note. Yes, I do.
And you, my understanding of the facts as well as the pre-sentence report is you don't even really remember much of the incident because you were so drunk. But you got behind the wheel of a car under those times. And you believe that because you have stayed out of trouble in the last year and have taken care of your children and your other responsibilities, that you have somehow should be rewarded for that by getting a dismissal?
No, not being rewarded. I mean, I don't know. I'm just saying, like, with being on probation, if there's a less timing, I mean, I could be on, or less than 8. I know they were saying like 6 to 8 months. So I was saying, I don't know.
Yeah, MB, you nailed it. She's entitled. That's just, again, that was the dumb question to ask when it's your allocution. You're supposed to say, I'm sorry, I'm not going to do this again. I've been working on my life. Thank you for the court. Like, things like that. Not dismiss this. I've been good for a year. You've been good for a year. Yeah, you were almost a 0.3. You're lucky you're alive, or you didn't unalive somebody else. Yeah, you're not getting this dismissed. In 8 months? I thought standard probation was generally a year. 8 months. Just saying.
The request is for you to do 8 months of probation and to participate in some programming to address your alcohol use, and outpatient, if necessary, would be sufficient due to the high blood alcohol level. One thing I didn't hear neither you or your attorney says is that since this time you've refrained from alcohol. I've not heard that. And so alcohol may still be a real issue for you, or your ability to engage in the consumption of alcohol and make good decisions after that may still be an issue. So I think a term of probation is appropriate.
Okay.
And I will adopt the recommendation of probation. You will be sentenced to a term of 8 months probation. While on probation, you have the following conditions. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. Do you understand that?
Yes, I do, Your Honor.
Okay. You're not to be at any bars or nightclubs while on probation. You are going to be required to submit to random preliminary breath testing and urinalysis testing, and you have to pay the fee for that, okay?
Yes, ma'am.
Okay, then. Let's see here. I'm gonna order that you participate in alcohol education. And that you will do outpatient abuse as recommended by probation. You'll maintain employment and provide evidence of that to our probation department. You're not to possess a firearm, ammunition, or weapon of any kind. There's a $30 per month oversight fee that you're responsible for while on probation. There is a $50 state minimum cost plus a $75 crime victim rights fee that will also be assessed. And you owe the Lansing Police Department $384.95 for OWI cost recovery that you must pay. So your total fines and costs is $749.95. You'll make no less than minimum monthly payments on that. And then lastly, there's an advice of rights as to probation that will give you the opportunity to request to be discharged early after you've completed half the original time ordered by the court, so long as you've not had any violations within the 90 days prior to that request. You will use the court's MC 512 form, which is on the court website, and you can get it from your probation officer. You will serve a copy of that form to the city attorney's office and to probation. The city attorney would have 14 days from receipt of that written request to file any objections to your early discharge. So you must have not had any violations, and if I ordered you or you were ordered to do any programming, you would have to have completed all of that programming before making such a request for early discharge after 4 months. Do you understand that?
Yes, I do, Your Honor.
If I set it for a hearing to address your request, which I have never done, but it could happen, you would have the right to hire an attorney to represent you for such a hearing. You would not have the right to court-appointed counsel for any hearing for early discharge. Do you have any questions at this time?
No, Your Honor.
You need to check in with our probation department and make sure that all your information is accurate. We have a number ending in 6674 for you.
Correct.
That's okay.
Yep.
They'll prepare a judgment of sentence for you to review and sign, and you will be reporting monthly via Zoom for your probation. Do you have any questions?
No, Your Honor.
Okay. Any additional matters for the record?
Nothing further from the city, thank you.
Not for the defense, Your Honor.
Okay, you're all set, ma'am.
Thank you.
Thank you.
You're welcome.
Yeah, I would have doubled down. So you're telling me this isn't going to be dismissed? What if I do probation really well? Will you dismiss it then? I don't want a DUI on my record. Did you see how high that BAC was? Makes me look like a drunk. Man, can you help me, Judge? Sparkle Poots, thank you so much for the 5 gifted memberships and welcome to the 5 new members. Thank you so much, Sparkle Poots. Very generous of you. A girl named Joe became a new member. Thank you so much. Welcome to the family. Thank you. And she also gifted a membership. Thank you so much, a girl named Joe, and welcome to the new member. Very generous of you, a girl named Joe. Thank you. All right. Are we moving to the last one? We might have 2 left. Let's see. Yeah, this. I don't remember if it's the last one or not, but of course we're staying in Judge Simmons' court. This one, no, we just got a lot of yelling back and forth. This one's not really too exciting, but this lady's not happy, so it makes it interesting. And because we're doing a spicy court night, we're just gonna stay spicy.
Joe is here on which matter?
He is here on U.S. Bank versus Erica Surfer.
Oh, that's right. She's no longer, okay. Well, I don't know what kind of motion it was, because I don't know.
Unmute. Garnishment and judgment.
Okay, you printed actually.
Yeah, I was gonna cut that out because there wasn't really a reason for it, and there's about a minute of dead air, but I didn't want to. She had a walk-up music. It was very important for the performance she's about to give us.
Okay, on the record, in the matter of U.S. Bank National, DBA Elon Financial Services versus Erica Burton, also known as Erica Meserva, 18-04202, GC, counsel appearance.
Good afternoon, Your Honor. Andrew Tetro for the plaintiff.
Okay, and then Ms. Burton is present via Zoom without counsel. I have a motion here. It says, I am motioning to stop garnishment and appear before the court as I was never received any documentation regarding this case prior to January 2025, and I have never been associated with anything regarding U.S. National Bank. Let's see here. Okay, counsel, you did get a copy of.
Yeah, I always get jealous when lawyers have better setups than I do. I see it occasionally. You have a lawyer with they're on Zoom and they have a professional mic, professional lighting. It's like, man, maybe I should just be a lawyer so I can get a proper setup.
The motion.
Correct, Your Honor.
Okay, it's really an objection to garnishment, but it's filed as a motion. Did you want to respond?
Just to say that plaintiff's position is that defendant hasn't raised a valid objection to the garnishment pursuant to MCR 3.101K, and that's all.
That is okay. And ma'am, you received the garnishment. Let's see here. Counsel, can you make me aware of just for my information, because I cannot get into my file. I see the request for garnishment and it's an address on Jennings. Is that the same address that was used to serve the complaint?
I don't believe so, Your Honor, but I'm going to pull up the documents and confirm it right now if you can bear with me.
Okay.
I think at some point after the default judgment was entered, we discovered that there was a new address, but I'm trying to pull that up right now. I will say that my record does show that the summons and complaint were served personally on the defendant.
Okay. Okay, ma'am, you have filed a motion, but it's really called objection to a garnishment. And when you file for an objection to garnishment, the rules for the civil court procedure are very specific, and you have to assert one of those reasons as a valid claim as to why they can't garnish your wages or seek garnishment recovery on this. Your statement is that you never received documentation regarding this prior to January 2025. That is not a valid objection to the garnishment. So that's really what you're doing now, is attacking the judgment, and the court rule specifically states that you cannot attack a judgment through the garnishment.
Your Honor, I called the 48th district or 54A district court and was told by a court, I don't know if they're officers or what they are, that this is what I had to do, was file a motion to appear. That's what I was told by the courts to do. I have never heard of U.S. Bank National or anything, and I've never received anything personally to me, any documentation prior to January of 2025. I don't even know what this case is about.
I recognize what you're saying. However, what I'm telling you is that the court rule, Michigan Court Rule 3.101, K2, says objection shall be based on one or more of the following. So these are the valid ways that you can get an objection granted. You have to assert that the funds or the property are exempt from garnishment by law, that the garnishment is precluded by pendency of a bankruptcy proceeding, or that the garnishment is barred by an installation payment order that you've already been entered into, or that the garnishment is precluded because the maximum amount permitted by law is being withheld pursuant to a higher priority garnishment. So that would be like if you had another garnishment that had higher priority and the max amount of money is being garnished through that. Or the judgment has been paid, or the garnishment was not properly issued or is otherwise invalid. Or lastly, the balance on the statement sent pursuant to MCL 600.401258 is incorrect. So you've not asserted any of those things. What you're doing is attacking the validity of the judgment, meaning because you're saying you never heard of this, so there can't be a valid judgment, and that you can't do that under a garnishment order, is what the court rule says. You understand that?
What I'm not understanding, Your Honor, is when there was ever documentation given to me to appear to court for the garnishment to be ordered to begin with, I was told by the court to file a motion to appear to fight the garnishment. I was never told that I had to file an objection and what the objection should be. How would you like me to proceed? Because I've never heard of this. I don't have documentation to proceed to know how to file an objection because I've never heard of this case until now.
Okay, so
all right, a lot of things here. First off, the court staff isn't supposed to tell you what you should do. I'm not saying they don't. They're pretty much told not to. Maybe not pretty much. They're told not to. And if they're telling you what you should file, that generally means you told them something, and like, oh yeah, you need to file this form. Probably didn't give them the full story. Otherwise, they would have said, I can't give you legal advice. I'm not an attorney. That's what I'm guessing would happen. So she's trying to throw the court staff under the bus. It's not going to work. No, it's not going to. Sorry, lady.
But it sounds like you got the garnish. It sounds like you got the garnishment. You called the clerk's office and they told you that your recourse would be to file an objection or a motion. And so that's what you did. But they're not attorneys. They're not supposed to advise you on what your recourse of action is, nor am I in a position to advise you of what you're supposed to do. You filed a motion. I have construed it as an objection because the motion doesn't really say what it is in the first place, other than that it's disputing the garnishment. You wanted to stop the garnishment. So that's what we call an objection to garnishment. And so that is controlled by the court rules. And the court rules give me very specific ways in which I can grant your request to stop a garnishment, but you've not given me one of those ways. So I can't grant it.
So Your Honor, do I refile an actual objection and then proceed? I guess I'm just not sure what I'm supposed to do from
you
now.
can file. I have already construed your motion as an objection. So you refiling it as an objection, saying the same thing, will only get you right back where you are now, which is a denial of the objection, because I can't grant an objection because your reason is that you never received any documentation regarding this case. So the way the civil procedures work is there is a summons and complaint under the lawsuit that's filed. So you were sued, and that they filed a proof of service. That's why I asked him what the address was. That
I absolutely love Judge Simmons' hair, and I love that it's about on a weekly basis she changes it, and sometimes it's something eye-catching, sometimes it's just kind of normal, and so yeah, we're not hating on Judge Simmons' hair. I need to catch up on some of these because I think this is the last case of the night. I'm gonna say Lady Rue. I'm hoping that's correct. Thank you so much for becoming a member. Welcome to the family. Thank you. You are awesome. And Chrissy, thank you so much for the super chat. Hey, Colin, sending you hugs in Florida. Hugs and Florida. You're sending me hugs in Florida. Sending me hugs from South Florida. Sweetie pie. Oh, sweetie pie. Thank you so much, Chrissy. I appreciate it. All right. Let's keep going.
they served you at, that they filed a proof of service. He says that the proof of service is indicating that you were actually served in person. This is a 2018 case. I don't have access to the record to find out exactly when you were served, but that's information that the clerk's office could provide you. It says that you were served in person. The law gives you a time frame during that service for which you're to respond and appear in the lawsuit. And then it also allows you to proceed with a pretrial and demand a jury trial, but to litigate the case. I'm assuming there was a default judgment that was in this matter because you say you don't know anything about it. And so when that happens, if there's a default judgment, there's a time frame per the court rules that allows you to set aside a default judgment. You would file a motion to set aside the default. And then the court will have a hearing to address whether or not you have sufficiency to get that motion to set aside the default granted. Or you can, if there was an entry in other ways, you can find another way to appeal to get that reversed. What you're doing is attacking the garnishment. You cannot attack the judgment through the garnishment. The court rules are very specific as to that. And it says MCL 600.40125A may not be used to challenge the validity of the judgment previously entered. That's exactly what you're doing. You're challenging how valid the judgment against you is by attacking the garnishment. And you've not sufficiently pled a reason for me to grant your objection to the garnishment. So I cannot grant that for you, ma'am. Do you understand that?
How was I supposed to go through that whole process you just talked about filing before within those amount of days or whatever else? I never received the documentation. I never even knew.
I can't give you those kind of answers. I recognize that your position is that you never received the paperwork, or you were not aware that there was a lawsuit. They have paperwork to the contrary that says that you were served in person.
So do I get a copy of that paperwork? Because what was the address and the exact date that documentation was supposedly given to me in person?
You can contact the clerk's office that told you to file this motion and get a copy of whatever's in the file.
They would not give me the information. I've already tried. They wouldn't give me the information.
You asked for a copy of the file and they didn't give it to you?
Yes, I did, because I don't have it because I never received it and they wouldn't give it to me.
You can always make a FOIA or a subpoena request to get a copy of a file. I don't know who told you that you couldn't get a copy of any proof of service that was filed, unless it's beyond the retention record, and I don't believe that this is a case that would be beyond that. The other option is you can get a copy from Mr. Tetro, who's here on behalf of the plaintiff, who's seeking the judgment against you. They can send you a copy of everything that they filed against you, including a copy of the proof of service. You can work with them to do that. But the court can't explain to you how you were supposed to respond to a lawsuit that you were named in. I can't tell you that.
All right, now I feel like she's making things up. first she has this made up. I'm not going to say that the court the court clerk was making things. Sorry, let me start over. I'm starting to trust her less and less, and let me explain why. That's how I should have started it. She first was kind of misstating what a court clerk would tell her about filing in the appropriate file, so that didn't sound right. Now she's saying that they told her no, that she couldn't get the court file. See, now like that stuff doesn't happen. So unless she just got someone that just didn't like her and was walking out the door, which I guess is possible. Yeah, I don't trust her anymore. She is she is not a trustworthy narrator. Throw her out. Throw her out. All right. Sorry guys. We're almost done with this. We've only got about a minute left. Let's go.
If you'd like, I can put you and Mr. Tetro in a private meeting room so you can exchange communication mediums, and he can send you your request.
Please.
For the record, the motion or objection is denied. Counsel, can you provide the court with an order?
Yes, Your Honor. When we're done in the breakout room, are we good to just leave, or do you want us to come back on the record?
Nope, you're free to go after you're done in the breakout room.
Okay, thank you.
I was trying to pause it right at the end. I missed it. All right. Well, as you can see, that is it for tonight's show. I do want to say something. I want to say something before we peace out. And it's important. So don't. I know you guys all like to leave the second it ends, but hold on, just hear me out. So I have had a kind of a rough couple days for YouTube over the last couple days. My videos haven't really been getting a lot of views lately, and it's just it's just been bad timing. And I've kind of been a little bit down on YouTube over the last couple days. And I received a phone call today, about 10 minutes before I went on stream, and I just want to say this. It was Andrea. Andrea from the Haley case back in last year. And what was it, October, November? You guys remember that case. And she just called me just to check in on me, to tell me again how much she appreciated everything I did for them, and wanted to make sure that I said thank you, or made sure that she said thank you to all you guys as well. And it absolutely changed my mood. So I went from like, man, my YouTube channel is not doing well right now. What am I doing wrong? And I've been like just a lot of self-doubt, right? Because there's a lot that goes into a channel that actually works, and views are the number one metric. So I'm just like going up and down trying to figure out what I can possibly do to change that. And I got the phone call that just like, you know what, it's worth it now. It was worth it. Stop it. I needed that phone call, and it was right at the right time. So yeah, so I guess that's a quick update on Andrea for her and Haley are doing great. So she wanted to say that. She just wanted to say we're doing awesome. Thank you so much for everything you did, and make sure you tell your community that we're very appreciative. And that's all it was. It was about a 30-second phone call, but it was very much needed, and I wanted to share that with you guys to let you know, she's still deeply appreciative, and so is Haley. So very yeah, I guess that's it. That's all I had. All right, yeah. Let's see. You guys are super chatting. Hold on. We got Clip Clop for 13 months. Thank you so much, Clip Clop. 13 months. That is awesome. I appreciate it. Blue Strat Dude for 3 months. Thank you so much, Blue Strat Dude. I do appreciate it. Sparkle Poots. Whose butt I got to kick? Andrea. No, we're not kicking anyone's butt. Sparkle Poots. But thank you so much for the super chat. And then Barry, of course, Barry Whitecat. Don't make me go chew on the internet wires. I mean, I'm leaving. So if you want to chew on the internet wires, I'll just replace them by tomorrow night. But yeah, thank you so much for the super chat. All right, let's move on. I just wanted to share that quick update. And it was awesome to hear her voice. And, it was just an unprovoked call. Unsolicited call. Like I haven't talked to her in, I don't know, it's probably been a month since the last time I talked to her. Like I try to text her every once in a while. She texts me every once in a while, but it's just one of those relationships that we're not like best friends, right? Like I would call her a friend, but it's just we don't talk that often. So it was just nice to hear her voice. All right, that is it. You guys are awesome. Thank you so much for hanging out with me tonight. Biggin, I know you're not here, but thank you so much for the Biggin Raiders and Biggin for the raid. You guys are awesome. We are rating KDZ tonight. Tonight is Booze and Body Cam, and every Wednesday night I try to alternate. Sometimes I think I forget who I rated last week, so I don't know. But I either do K4 or KDZ on Wednesday. I think I did KFAR last Wednesday, so we're going to do KDZ tonight, I think. I actually have no idea. So next Wednesday, help me remember that we did KDZ tonight, so it's KFAR next Wednesday. All right, you guys are awesome. I will see you all tomorrow night. Until next time, bye. Wait a second. You're right. This is Tuesday. Why are they doing Booze and Body Cam tonight? Don't they do that on Wednesdays? Oh, man. We're still rating KDZ. Hold on. Does it say tomorrow night? No, they're doing it tonight. Okay, I'm confused. But thank you for letting me know it's Tuesday and it's not Wednesday. But yeah. All right, let's just go. Have a good night, guys.